Nases. This will be my video lecture in legal aspects in the tourism and hospitality industry. Now for today, we'll be starting a new topic because we were able to finish already the topic on obligations and contracts. So today, we start with a new law. No, and this law is called the Labor Code of the Philippines. No, the Labor Code is the law, the particular law that protects the rights and responsibilities of both the worker and the responsibilities of the employer. No? So the Labor Code was enacted. No? The Labor Code, this is the law that will govern the relations between workers and his or her employer. No? So the Labor Code is what? PD. No, this one is the law, no? PD 442. This is the Labor Code. Labor Code of the Philippines. No, this one is the particular law that governs, no, the rights, duties, and responsibilities of workers as well as of employers. No, so the Labor Code of the Philippines was promulgated by President Marcos, and this one is PD number 442. No, so you should remember this. PD 442 was promulgated on May 1, 1974. No, and according to this law, no, because a PD is also was also considered as a law enacted by then President Ferdinand Marcos, no, the senior, not our current president. It was promulgated on May 1, 1974, and according to this law, this labor code will take effect 6 months after its promulgation. No? So this one became effective, valid and effective for implementation on November 1, 1974, because according to this law, it will become effective 6 months after its promulgation. Now, meaning, if you count from May 1, this is the date when it was promulgated or when it was made, no? 6 months will be, the effectivity date would be November 1, 1974. Clear so far? So PD 442 is the Labor Code of the Philippines. Now, when we talk of the Labor Code, why does it concern you to study the Labor Code or some provisions of the Labor Code? No? Why is there a need for you to study certain provisions of the Labor Code? Well, basically, because when you are a tourism and hospitality professional, there are times, or when you put up your own business, for instance, or even you become an employee, of course, first of all, when you become an employee, you need to sign. Need to sign what? What are you going to sign? An employment contract. No? Employment contract. Of course, no? When your services has been engaged by one party, of course, you need to sign an employment contract. Or if you have your own business, say for instance, you become an entrepreneur, no? If you become an entrepreneur, of course, what are you going to sign? Of course, the employment contracts also of your employees, no? Employment contracts of your employees. So you have to familiarize yourself with the Labor Code. Or if you become an independent, say for instance, contractor, for instance, and your services was engaged, of course, you have to sign a contract of services, no? Whatever service is that, no? Say for instance, if you are a what's this, wedding planner, for instance, of course they have to contract your services, and there are terms and conditions that you have to observe, no? And we call those terms and conditions as stipulations. Clear? So far? No? You become an employee, for instance. I repeat, when you become an employee, you need to sign an employment contract. And of course, when you sign an employment contract, you need to know provisions of the labor code, no? Provisions of the LC would be labor code, no? Or if you are not an employee, you are the owner of the business yourself, you become an entrepreneur, so you need to prepare also an employment contract for your employees, no? So of course, that will also require a knowledge of the labor code. Or if you are an independent contractor and your services has been engaged by somebody else, of course you also prepare a contract of services. Okay, clear so far? So it is very essential for you as a tourism and hospitality professional to prepare employment contracts, or you should know the laws that will govern the relations in your workplace. Huh? Okay? Clear so far? So, if you're engaged in the tourism and hospitality industry, no, if you are already there, no, if you are already employed in the tourism and hospitality industry, for instance, or your business is engaged in the tourism and hospitality industry, of course, what am I talking about? No? Well, I'm talking about, say, for instance, the components of the tourism and hospitality industry. Say, for instance, food and beverage, no? Food and beverage services. These are the things that I'm talking about, no? Food and beverage services. No? What else? No? Perhaps accommodation, no? Because these are all engaged in the tourism and hospitality industry. What else? Transportation services. Transportation services. Diba? So, if you will be engaging in transportation services, what else? Travel agencies. No? Travel agencies. Or perhaps tour operation companies. No? You may be engaging in tour operation companies. No? Or what else? Well, if you have been engaged in, say, for instance, attractions, no? Yung mga site attractions, whether natural or cultural, no? So, these are all engaged in the tourism and hospitality industry, and these components that I mentioned will cover this. So, and of course, when you have been engaged in any of these components, you need to sign a contract in whatever form. Perhaps you as the employee, you as the entrepreneur, or you as the independent contractor. Okay? Clear so far? Now, the problem here is that, well, I'm not saying that you may be harmed by those in the accommodation will be hotel, motel, hotels, motels, inns, etc. No? That's what I'm talking about. Now, if you have been engaged as a professional in the tourism and hospitality industry, of course there are problems, no, or challenges that you need to solve, or you need to surmount. No? There are challenges, and we could not avoid these challenges because that is a part of your work. No? So let us see the challenges that you may be encountering. No? Challenges in the hotel in the hospitality and tourism industry. So the challenges may come in the form of, what do you foresee? No? Poor wage and working conditions. No? This is a problem, no, among tourism professionals. Diba? Poor wages and working conditions. What else? Um, well, you may encounter unequal treatment also from your employer, unequal treatment. But, or you may encounter sexual harassment because you are beautiful and you are very attractive to some people. So you may encounter this. What else? Well, you may encounter undemocratic and rigid, very rigid corporate culture. But corporate culture. So these are all problems, no, that you may encounter. What else? Well, you may encounter political instability, no, in the place where you will work, no, especially if you're working in the Middle East or in a third world country, no, you may encounter, and this will also affect, no, of course, your work. And then what else? Aside from this, seasonality of work, no, seasonality, meaning your work may only be good for a season, so you have to deal with that also. So these are the challenges that we could find also in the tourism and hospitality industry. Now, to protect yourself with all these problems, of course, the basic thing that you will look for, because that will lay down or that will set forth the terms and conditions, would be put in a contract. And when you are employed, say for instance by a business entity or business concern in a tourism and hospitality industry, it is a must that it has to be reduced into what we call a contract or an agreement. Okay? And of course, if you are a worker, there is a need, of course, for you to know the labor code provisions. No? The labor code provisions. Now, let us take this now as the new topic that we will study for the next meetings, no? Today and for the next meetings. No? So when we talk of the labor code, no, what does it compose of? I have shown you the book, Labor Code, PD 442. So here, first I will discuss the what? Labor laws, no? The composition or classifications of labor laws, no? The first is what we call, there are protective legislation, no? We call that protective legislation, no? When we talk of protective legislation, of course coming from the word protect, no? There are laws relating to employment that protect, no, the rights of the weaker party. The weaker party. And who is the weaker party? Usually it is the employee, no? And the employee usually, if we clarify this first, especially women, no? If you employ women, children, and other vulnerable groups like, say for instance, PWDs, no? If you employ them, they are the weaker party. So protective legislation is part of labor laws that will, of course, protect and ensure that the weaker party will not be abused. Here, example, for instance, example would be, well, child labor laws, no? So, child labor laws, no? There is the protection of children working, or laws that will protect women against discrimination. So, diba? There are laws that will protect women against discrimination. So, or even anti-sexual harassment law, no? Anti-sexual harassment law. So, these types of laws are examples of what we call protective legislation, which is a type of labor laws. Here, so far, so I repeat, when we talk of protective legislation, under the labor laws, we are talking about the protection of the weaker party. And who are the weaker parties? Well, usually it's the employee, and example of employees that are frequently abused will be women, children, or even PWDs. Now you ask me, are children allowed to work? Well, under certain conditions, no? And examples of protective legislation will be child labor laws, women against laws that will protect women against discrimination, and anti-sexual harassment laws. So that is the first kind of legislation under labor laws. We proceed with the second one. No? The second is what we call administrative legislation. No? This is the second type of labor laws. No? Administrative legislation. So what is this in particular? Well, these ones are, say for instance, issuances, no? Coming from or enacted by administrative bodies, no? Administrative bodies or agencies, no? Administrative bodies and agencies. And what are these administrative bodies and agencies? For instance, well, we have the DOLE, no? So the DOLE, time and again, or every now and then, they issue issuances which will of course govern also employment law, no? DOLE, perhaps even the SSS would issue, and these are administrative bodies, no? SSS, even the PhilHealth will issue some rules or regulations. PhilHealth, even the GSIS. So these are the administrative bodies that I'm talking about. And every now and then, these agencies will be issuing what? Rules or memoranda, for instance, or even circulars that will govern employment what we call this, employment status, or anything about employment, no? Okay, so this is the second type of labor laws, administrative legislation. The third is what we call social or welfare legislation. So what are social or welfare legislation? Well, this type of laws has something to do with ensuring that the worker is taken care of by removing his insecurities. No, his insecurities while on employment. What are these insecurities? Well, say for instance, if he is out of work, and of course there are hazards arising from his work, So this is also arising from work. This is also covered by what we call social or welfare legislation, no? The intention is, of course, or the objective is to remove certain insecurities of the employee or the worker, no? Because you see, when you are out of work, what will happen to you? If you have been injured or granting that you become incapacitated because of hazards arising from employment, of course, there is somebody who will take care of that. And usually it will be the SSS for private employees. We have the GSIS for government employees. No? Example of this will be the Workmen's Compensation Act. No? This is a law that will fall under social or welfare Workmen's Compensation Act. No? or even the law on SSS, GSIS, on even PhilHealth. These are laws that are intended to benefit workers or employees when that will protect them against hazards arising from employment. Okay, clear so far? And then the fourth type of labor laws legislation is what we call, this is the fourth, no? Is what we call the diplomatic, no? Diplomatic legislation. So what is this diplomatic legislation? Well, we call this usually the ADR, no? ADR. What is ADR? Alternative Dispute Resolution, no? And when we talk of the ADR, we talk about solving a labor dispute, no? Labor dispute, yung away-away sa labor. When we talk of the ADR or the Alternative Dispute Resolution, we're talking about solving the labor dispute or problem arising from employment out of court. Meaning, hindi siya ilalagay sa korte. It will just be through ADR or what we call the Alternative Dispute Resolution. And what are examples of the ADR? Well, we have arbitration, we have mediation, we have conciliation, we have the grievance committee, no? Or grievance machinery. What do you notice among this? Well, what you notice about arbitration, mediation, conciliation, or grievance machinery, this is solved through out of court, hindi sa korte. No? It will be outside of court. There are two more kinds. No? There are two more types of labor legislation, but that will take a long time to discuss. So I will be discussing that next meeting. Your assignment is of course to list down, no? I forgot the number because I do not have my notebook with me. But your assignment, your written assignment, I will be giving the assignment number next time, no? Next meeting. Your assignment is to find or to list down, no? To list down all provisions in the Constitution that affect the labor sector. No, I repeat, there are plenty of them. No, I'd like you to find all the specific provisions in our Constitution that affect the labor sector. No? Okay, I think that is all for today. I will continue my discussion on the other two types of labor laws next time. Good afternoon.